Yes, please, we can start now.
Okay, thank you. Good morning. My name is Yuwen Li. I'm a professor of Chinese law at Erasmus University, Rotterdam, the Netherlands. A warm welcome to everyone to our online guest lecture, which is a part of the EU-funded project called EUPLANT, EU-China Legal and Judicial Cooperation. Today, we have the great pleasure to invite Professor Marina Timoteo from University of Bologna, Italy, to give us a lecture on the topic of Chinese law in the age of digital sovereignty. Marina is a professor of comparative private law. From her impressive and excellent resume, I must say it is rather difficult to summarize all of her achievement in a few minutes. But I believe the following points definitely stand out.
Okay,
Marina
sorry.
has the expert.
Oh, please go on, sorry.
Marina has the expertise and also the experience of decades of research and teaching in contemporary Chinese law. Her research focuses on the process of legal modernization and integration, EU-China relations, contracts, intellectual property, environmental law, digital innovation, and legal reform in China. As a European scholar, Marina is dedicated to and also a real expert in Chinese law study. She not only teaches Asian law and Chinese law and business in Bologna, but also she is a visiting professor in many Chinese universities, where she teaches European and international law. She serves as advisor and expert in several Italian and European organizations on Sino-Italian and Sino-European relations. She is also the coordinator of several research and cooperation networks and projects between Europe and China. It is safe to say that Marina's expertise and contribution truly act as a bridge between Europe and China in legal research and cooperation. And lucky for us today, we will have the chance to know more about Chinese law from her unique perspective. Before we start, just a quick reminder to the audience. If you have any questions during or after the lecture, please feel free to type your questions in the chat box at any time. After the lecture, my colleague, Dr. Bian Cheng, will read the questions and moderate the session. And now, Marina, the floor is yours.
Okay, can you hear me?
Yes, very good.
Okay, perfect. So first of all, I would like to thank you for this kind invitation. Thank you to Professor Li Yuwen, who was also guest lecturer at the University of Bologna last November. And thank you to Professor Cheng Bian for organizing the today's lectures. As a logistic information, we have 1 hour and a half in all. I mean, also with question and answers, or 1 hour and a half of lesson and then question and answers?
I think we plan for 1 hour.
1 hour, okay, 1 hour, no problem, no problem. Okay, can you see the PPT? Okay, and if I move it, can you see when I move it?
Yes.
Perfect.
Yes.
Wonderful. Okay, so this lesson is about digital sovereignty, a quite new topic, but not completely a new topic. In any way, is a very contemporary topic. This topic has been increasingly used in a variety of contexts, and digital sovereignty has been emerging as a multidimensional concept. Today, I will introduce this concept and the growing use of this concept applied to the digital realm in China, and look at 2 aspects which have been affecting the legal evolution as a part of the story of digital sovereignty. I mean, data and artificial intelligence. But it's important to see that this is not only a Chinese story. In order to have a deepest look at this story, we need a comparative law perspective, which means, first of all, to frame the Chinese situation in the global history setting. Let's start with the analysis, a short analysis of the two words which are part of the expression digital sovereignty. First of all, sovereignty, which is a concept linked to the modern state. It comes from the Latin word superanus, which means over or superior, and it is connotated as a political and legal concept for the modern state, linked to the idea of the power enjoyed by a governing body to rule over itself, free from any interference from outside sources or bodies. Whereas the traditional theory of sovereignty, as proposed in the 16th century by French political philosopher Jean Bodin, concerned the ruler's authority to make final decisions, Jean-Jacques Rousseau recast the concept so that it focused on popular sovereignty rather than monarchical sovereignty. Over time, it became increasingly associated with democracy, rule of law, and territoriality. Today, sovereignty always primarily means state independence vis-à-vis other states, and this is the external sovereignty, as well as its supreme power to command all powers within the territory of the state, and this is the internal sovereignty. In any case, sovereignty is linked to a territory. We know sovereignty mainly marked as a territorial dimension. But since the late 20th century, it seems that a crisis of state sovereignty started. And this crisis seems to be linked to global market economy and to the internet development and the growing importance of digital network communication. The emergence of global market economy is one of the reasons for the crisis of state sovereignty. While the history of sovereignty culminates in its concentration in the nation state, it's challenged by the market economy and its natural tendency to expand beyond the politically. Consequently, crucial features of state sovereignty has been weakened, such as its ability to make and enforce laws, power to define and defend territorial borders, as well as the capacity to shape and regulate economic performance and affairs. The idea of state sovereignty was particularly challenged also by internet's development. The growing importance of digital network communication implies the demands of state sovereignty, as the digital space does not have relation with the spaces defined by territorial boundaries. So this crisis is linked mainly to global economy and to the emergence of internet and sovereignty of states. But on the same time, internet was also the occasion to start talking about a new sovereignty. So it was supposed to end sovereignty, but it was supposed also to start a new season for sovereignty. And new concept of sovereignties have been developing in relation to the new internet environment. And I took here this idealistic declaration made in 1996 by an American internet activist, John Perry Barrow, who spoke to the world's government and said in the Declaration on the Independence of Cyberspace, governments of the industrial world giants of flesh and steel, I come from cyberspace, the new home of mind. On behalf of the future, I ask you of the past to leave us alone. You have no sovereignty where we gather. And this was a new talk about sovereignty, just in relation to the new internet space. So, internet was supposed to end sovereignty or to start a new season for theory and reality of the concept of sovereignty. And comparative law scholars and mostly international law scholars who try to manage with this new concept of sovereignty in the contemporary internet era. And here I quoted another sentence written by Andrea Leiter, who wrote an article in the Harvard International Law Journal Frontiers last year, talking about cyber sovereignty, which is defined as a techno-legal sphere characterized by claims to governance by state, companies, and individuals. So new discourses on sovereignties started after the emergence of internet, a rethinking on the concept of sovereignty, new applications of the concept of sovereignty, a new life for this concept, new sovereignty. And China has started inserting these new concepts, and the first steps were in the field of cyber sovereignty, which was mentioned by the German scholar, which I just quoted. And we start finding the concept of cyber sovereignty in the political and legal documents in China since the second decade of 21st century. And in particular, it was the International Strategy on Cooperation in Cyberspace issued in 2017 by the Ministry of Foreign Affairs and the Cyberspace Administration of China, which for the first of all put the concept of sovereignty in cyberspace in the first place of the political, internal and international strategy, political strategy of China. And here we have a deep study of Roger Piemers on this international strategy, which introduced the new concept of sovereignty in cyberspace for China. Let's have a look at this document, which are the main factors related to the design of a new cyber sovereignty for China, which is the concept, which is the strategic role. First of all, this document provides a comprehensive explanation of China's policy and position on cyber-related international affairs, as well as the basic principles, strategic goals, and plan of action in its external relations on that front. And we read this in the preface of the document. And then in the document about the strategic role of sovereignty in cyberspace for China, we read that the strategic goals of China's participation in international cyberspace cooperation are to firmly safeguard China's cyber sovereignty, security and development interests inside cyberspace, ensure safe and orderly flow of internet information, improve global connectivity, safeguard peace, security and stability in cyberspace, but also enhance international rule of law in cyberspace, promote global digital economic development, deepen exchange and mutual learning of cyber culture, so that the achievements made in the development of the internet will benefit the world and bring better welfare to the people of all countries. So this is the strategic role of cyber sovereignty outlined in this document. And amongst the basic principles, we find the principle according to which country should respect each other's rights to choose their own path of cyber development, model of cyber regulation and internet public policies, and participate in international cyberspace governance on an equal footing. No country should pursue cyber hegemony, interfere in other countries' internal affairs, or engage in, condone, or support cyber activities that undermine other countries' national security. So this is one of the basic principles of this document. And on the European side, we also find a growing attention to issue of digital sovereignty. Today's lesson will put in comparison China and Europe, because there are a lot of links between the two in this new long march towards digital sovereignty. President Ursula von der Leyen states that it's not too late to achieve technological sovereignty in some critical technology areas, artificial intelligence, blockchains, and so on, saying that gradually Europe's digital sovereignty is taking shape. And in July 2020, the German government, in its official program for its presidency of the European Council, announced its intention to establish digital sovereignty as a leitmotif of European digital policy. And in order to better contextualize the situation, which is the international national and historical context took place, the international cooperation in cyberspace for the of concept of cyber sovereignty, digital sovereignty in the respective sphere. The context has been well described by Luciano Floridi. Luciano Floridi is one of the most prestigious scholars working in the field of digital information and digital sovereignty. And in a recent analysis of what Floridi defines a field for battle for digital sovereignty, the fight for digital sovereignty, he mentions some recent episodes which can give the idea of the context in which we are. July 16, 2020, the Court of Justice of the European Union held that the EU-US data protection shield was invalid, as the level of data protection in US was not equivalent to that required under EU law. In the same month, Huawei is a leading Chinese company in the production of 5G network and system. And there is a discussion in Europe about the initiative of ban of this technology for security reasons following US and Great Britain. In front of this perspective, China said, okay, you can ban us, but also she threatened that she may retaliate against two European companies, Nokia and Ericsson. And in October 2020, the Swedish government decided to ban Huawei from supplying 5G equipment due to security concern, and Finland did not follow in the first moment. And 19th of July 2021, this is a Reuters, the French press agency announcement, Nokia, the Finland company, won its first 5G radio contract in China, securing a share in one of the China's mobile 3 new 5G contracts, while the Swedish rival Ericsson lost market share after getting caught up in a political. Floridi comments, these are just a handful of examples during some ordinary weeks in the life of the digital revolution. These are all episodes in the fight for digital sovereignty. That is for the control of standard and protocols, processes, hardware, services, and infrastructures. In short, for the control of the digital struggle. The most visible clash is, on the one hand, companies design, produce, sell, and maintain the digital. This poietic power over the digital means that states depend on companies for almost anything that is digital, to the extent that, for example, companies have in some contexts become the first line of defense when it comes to cyber attacks. On the other hand, states have the power to regulate the digital. And this is a powerful form of cybernetic, which is a word deriving from the Greek word kybernetic, which means piloting, steering, regulating. So regulate the digital, it became a first concern. Regulate the digital means regulate data, regulate internet, and this is a first concern for a lot of states in the world. In China, for example, we have been assisting to the enactment of a new package of laws on data and personal information protection. And the key political objectives of this new package of laws was, first of all, to deal with US-China competition in order to strengthen control over key resources, data, for tech development, but also state capital dialectic, limiting the economic and political power of the big techs, which are competitors in the political arena. And last but not least, also to enhance state-citizen relations, protecting citizens' interests and try to manage with social discontent. So key aspects of digital sovereignty are digital data sovereignty and artificial intelligence sovereignty. And this is the reason why I decided to concentrate on these two specific aspects in order to see how digital sovereignty has been elaborating in the last few years. So we have the introduction of new concepts of sovereignty, first of all related to cyber sovereignty. And now we assist to the creation of a new concept of digital sovereignty, first of all, through the regulation of these two fields, data and artificial intelligence. Why these two fields? Because they are the two case areas of the digital field, which are deeply intertwined. And here I inserted a quotation by Kai-Fu Lee, who wrote a very interesting book on AI superpower China and US and China. And Kai-Fu Lee says, today successful AI algorithms need three things: big data, computing power, and the work of strong AI algorithm engineers. Bringing the power of deep learning to be our new problems requires all three, but data is the core. Without data, nothing can happen. The quantity of data is fundamental in determining the power and the accuracy and the algorithms of artificial intelligence. In 2017, The Economist article asserted the world's most valuable resource is no longer oil, but data. And the strategic importance of data as China, and not only for China, as we already said, Europe is a protagonist in this new context. And an example of the process of creating a digital sovereignty in Europe is to be found in the General Data Protection Regulation, which has forced companies around the world to comply with European practices on privacy and encourage similar regulations in other jurisdictions, including in various parts of the US and China. A similar opportunity has been recognizing to exercise regulatory power in the area of artificial intelligence. Some authors suggest that the focus on creating a European regulatory framework for ethical artificial intelligence could both inspire others to emulate it and force compliance with European ideas on how to control this industry in the future. Someone talked about the Brussels effect, ability for Europe to influence through promoting a circulation of legal models in these crucial fields of the new digital sovereignty. And data is deeply entrenched in the nearly every aspect of our life, economical and social, and not only. The COVID-19 pandemic has only accelerated these trends, as everything from commercial activities to education to entertainment have increasingly moved online, especially where pandemic-related restrictions were more severe. And for data, we mean here digital data, which is information in any interpretable form created, transmitted, processed, or stored via digital means. And these are the most relevant legislative steps taken in China to regulate data. We know that a new personal information protection law took effect on November 1st, 2021, but we also had before this the 2017 cybersecurity law, which focused on establishing a uniform regulatory regime for cybersecurity data protection, which was considered the pillar of the cyber sovereignty strategy in China. And in addition to the personal information protection law, we also have the data security law, which regulate mainly the data processing. And last but not least, we have the civil code, which includes specific provisions for the protection of personal information and also deals with data. Let's have a quick look at the rules of the code about personal information, which we find scattered in 3 books in the Zunzi, which is the general part, but also we have in the book of personality right and in tort liability book. The general rule contained in the MIPA Zunzi is in Article 111, which stipulates that personal information shall not be illegally collected, used, processed, or transmitted, and that the personal information shall not be illegally traded, provided, or disclosed. In the personal information protection law, there is a definition of personal information, which is all kinds of electronic or otherwise recorded information related to an identified or identifiable natural person. And this definition largely mirrors the ones that fall under the cybersecurity law and the Chinese civil code. It's important here to say that in the Chinese legal context, information, which is 信息, is different from 数据, data. They are 2 different but related concepts, interrelated concepts. And the civil code has explicitly distinguished data from the concept of personal information. And we should take it in mind to follow the future developments of this field of the law. That in Article 111, we have seen the general rule on personal information, and the general rule on data is inserted in Article 126 of the Civil Code in the chapter on civil rights, together with virtual assets. So there is a different attitude of Chinese lawmaker when they deal from a legal point of view with personal information, which is more linked to the idea of right to be protected, personal right to be protected, and data, which are also assimilated to the assets, to property. And we have a very recent evolution in this regard. We have to say that the national legal framework on personal information and data that we have just introduced is followed, is completed by several initiatives at the local level. This is the typical framework, Chinese legal framework. We have a set of big laws at the national level, and then we have to find the implementation rules in secondary and local regulations. And also in this field, we have a lot of local regulations and a new interesting new legal field which has been regulated in the last few months is that of the data market. And we have seen in November the creation of the Shanghai Data Exchange, which opened for trading nationwide on November 25, 2021. And on the same day, just linked to this new initiative, the Standing Committee of the Shanghai Municipal People Congresses issued the Shanghai Data Regulations, which implements the Personal Information Protection Law, the Cybersecurity Law, and the Data Security Law. So the regulatory framework of data, personal informations in China is quite complex, is made by national laws, but also by several local laws. And I would like now to concentrate our attention to some elements of personal information law in order to see how digital sovereignty, in particular with regard to the foreign countries, has been designed within this law. First of all, some general reference to the definitions. What is a personal information according to the personal information law? It means all kinds of information related to identified or identifiable natural persons that are electronically or otherwise recorded, excluding information that has been anonymized. Thus, the anonymization is an exclusion clause to define personal information. And we also know well this rule in Europe. Anonymization refers to the act of personal information handling which results in the impossibility to identify specific natural persons and restore during the process of personal information. So this is the general concept of protection of personal information under the new law. The legal circumstances of processing informations are stipulated by Article 13 of the law. And here, the most relevant element is the informed consent that we also know well in Europe. Data subjects have the right to know and the right to decide on the processing of their personal information and have the right to restrict or refuse the processing of their information by others. And we have the territorial scope, the problem of the territorial scope, which is very, very important to explore the issue of digital sovereignty. In which way this is China? Data have to be considered as something which has a territorial definition. This is the spirit of GDPR, and this is the spirit of Chinese law, which follows GDPR in this regard. And let's have a look at the two set of regulations. GDPR applies to entity which processes personal data as part of activities of one of its branches established in the EU, regardless of whether the processing takes place in the Union or not. However, GDPR applies to a company established outside the EU, where the processing activities are related to the offering of goods or services to subjects in the Union, irrespective of whether a payment on the subject is required. For example, a company established outside EU, which supplies online training courses to students in EU, or the monitoring of the subject behavior as far as their behavior takes place within the Union. And this is GDPR. And this is the Chinese law. It principally applies to organizational individuals handling personal information of natural persons within the jurisdiction of China, with the same exception as in GDPR. Article 3 of the law extends the territorial scope of the legislation to processing activities by handlers established outside China, similarly to the GDPR, if one of the following circumstances is present: where the purpose is to provide products or services to natural persons inside the border, where conducting analysis or assessment of activities on natural persons inside the border. More or less the same rules as GDPR. And in the Chinese law, we have another condition: if under other circumstances provided in law or administrative regulation allows to extend the territorial scope of the law to process activities by handlers established outside China. So more or less, we find a similar approach with the addition of this last clause, which is a typical clause which we find in the Chinese legislation, to leave the door open for additional regulations. The law requires handlers outside of China that process personal information of covered persons to establish a dedicated entity or appoint a representative with China to be responsible for matters related to their information processing. And this is a typical provision of a specific provision of the personal information law, protection law in China. And such entities must provide the name and contact method of the representative to the relevant department responsible for implementing the law. So these are the conditions about the territorial scope in the personal information protection law. Another problem which is related to digital sovereignty and relations with other states is that of cross-border transfers, which again has been regulated following on the wake of the European model. Transfers of personal information outside the border of China are regulated in Chapter 3, with the stated objective of ensuring that the transfer of data outside of China must be protected to the same extent as under Chinese law. It means they ask for a reciprocity principle, where a country or region adopts discriminatory prohibitions, limitation, or other similar measures against China in the area of data protection, China may adopt retaliatory measures against said country or region. This is stated in Article 43 of the law. And just have a look at the rules related to the cross-border transfer in GDPR and in the Chinese legislation. The relevant mechanism is that the evaluation of the operation of the cross-border transfer by the European Commission, and this is the so-called adequacy decision. So the cross-border transfer is allowed if, under the evaluation of European Commission, the third country offers an adequate level of protection, and in absence of an adequacy decision, the transfer can take place through the provision of appropriate safeguard and on condition that enforceable rights and effective legal remedies are available for individuals. Moreover, in an absence of an adequacy decision or of appropriate safeguard, a transfer of personal data to a third country shall take place only in specific cases provided in Article 49. One of the cases is that the subject has expressed explicit consent to the transfer after having been informed of the possible risk of such transfer. So we have a general rule of this adequacy decision. In absence of this decision, we have these other alternative possibilities. Chinese law follows the model, even if it seems to be a little bit stricter. The Chinese law requests a necessity test. This test means that, and it is made by the Cyberspace Administration of China, and it means that the necessity for business or other needs is acknowledged for the operation of cross-border transfers. In addition, not in alternative, in addition, handlers must provide specific further notice to individuals, regardless of what mechanism for transfer is used, and following this notice, handlers have to obtain the individual's specific consent. And these are the most relevant rules which in the new personal information protection law define the new field of digital sovereignty. They are mostly related to the territorial scope of application and to the cross-border transfer of data. And more or less, these rules are similar to those of GDPR. Another field where both Europe and China are building a regulatory framework which will affect the issue of digital sovereignty is that of artificial intelligence, which is made by data and information. We have a huge potential benefits linked to the artificial intelligence discourses, but also risks and harms, which calls for regulation. We face new challenges in all fields related to the operativity of artificial intelligence. For example, job automation and new massive pressures on working people, full and pervasive control of machines over human beings, supremacy of data over personal rights, first of all, privacy, online security, and the creation of new digital monopolies. And this called for a new aspect of the regulation, the ethical aspect. Artificial intelligence not only calls for legislative rules, it first of all asks for the definition of new ethical rules. And the issue of ethical guidelines for artificial intelligence has been raised as a key point of artificial intelligence strategies, both in Europe and China. Ensuring an appropriate ethical and legal framework for artificial intelligence is one of the pillars of the European Union Commission communication issued on artificial intelligence in April 2018, and the year before, also the Chinese State Council released a plan which is called a New Generation Artificial Intelligence Development Plan. So the two sides of the Euro-Asian continent, Europe and China, are both paving the way for a new regulatory season of digital, with particular regard to artificial intelligence, calling for the creation of an appropriate, not only legal framework, but also ethical framework. And just let's have a look at these two strategies and what these two strategies have produced until now. The Chinese plan, the objective of developing laws, regulations, and ethical norms are stated as one of the main strategic objectives. And the plan outlined 6 supporting guarantee measures for artificial intelligence development, which are develop laws and regulation and ethical norms. And this is the first one. And then other follows. Rules regarding intellectual property system, but also labor, and also research and development activities. In Europe, the work to elaborate ethical guidelines started in 2018, and in April 2019, there was the elaboration, the approval of artificial intelligence ethic guidelines, which have been drafted by a high-level expert group appointed by European Commission. And these guidelines set forth 4 ethical principles and a list of 7 requirements that artificial intelligence is present in order to be defined as trustworthy. And now we shall have a look. We shall introduce very briefly these ethical principles and compare them with the Chinese one. 4 ethical principles: respect for human autonomy, prevention of harm, fairness, explicability, to which 7 core requirements have been related. And we see which are the most relevant fields in which the ethical principles should be developed. Privacy and data governance, transparency, diversity, non-discrimination and fairness, environmental well-being, and so on. In China, following the plan which I before mentioned, it was created a new generation governments which worked in parallel with the European Expert Committee. It was composed by experts from academia and artificial intelligence industry, and in June 2019, it released the principles to develop responsible artificial intelligence for the new generation artificial intelligence. And the following principles were named as rules, as basic rules in developing artificial intelligence: harmonious and friendly, fair and just, inclusive and sharing, respect privacy, safe and controllable, shared responsibility, open collaboration, agile governance. So the approach was a little bit different, but the content of the principles is not so different. The explanation about the requisites are that, for example, for harmonious and friendly, artificial intelligence it means that artificial intelligence should promote the commonwealth of human community. Fair and just, it should promote elimination of prejudice and discrimination. Inclusive sharing means that artificial intelligence should promote green development. and overcome digital divide, protect privacy and development. So you see not so many different in principle between the two lists. We also have the mention of safe and controllable principles, shared responsibility, open collaboration, and agile governance. So if we compare the ethical principles and the Chinese principles and the European principles, we find a lot of correspondences. Privacy, safety and controllability, fairness, justice, non-discrimination, protection of environment, and so on. So about ethics and law, we have to say that this is a new concern, which is just put on the table in this construction of discourses on digital sovereignty and of the new regulation of the digital environment. Ethics and law. In China, we find some reference to this issue, ethics and law, and we find it also within the laws. For example, 2021 data security law, it requires that when conducting data processing activities, the entity should comply with laws and regulations, respect social norms and ethics. And in the civil code, we find that medical and scientific research activities concerning human genes and human embryos, among others, shall be carried out according to the laws and administrative regulations and relevant provisions issued by the state without endangering human health and violating moral principles. So we know that the ethic dimension in the Chinese culture is very important, and it has strict connections with legislative rules. And this new stage of digital regulation offers new occasion to deal with the relations between ethics and law. Another mention is we have a lot of examples of the use of the ethic element in legal reasoning, also in legal reasonings of judicial organ. We see here in a decision about e-commerce where the need to cultivate honest and trustworthy business ethics is stressed in the decision. It is a 2009 decision. And so, as a last word of this first introduction of the issue of digital sovereignty, we have seen digital sovereignty is, first of all, at the moment, considered a state affair. So each state is reestablishing new borders in the apparently no border internet world, in apparently no borderless digital world, new border established through laws, through regulations. And we have seen GDPR in Europe, and we have seen the personal information protection law in China, but also the data security law in China. But digital sovereignty, as I introduced in these last minutes of the lesson, is not only a state affair, because this need to stress more the ethic side of the regulation is something that can open a new era. I wrote in an idealistic way, it's a law renaissance occasion. I think that the contemporary era is calling for jurists which can be new creators of law in a fully global perspective, trying to seek and find law, all the more so by confronting knowledge on a wider basis, fostering dialogue between disciplines, first of all, ethics and law, and fostering intercultural dialogue between the Western and the Eastern part of the world. So this is the added value that the digital sovereignty discourses bring with us. And I hope we can be able to stress this added value and to develop a new season for law in the world. Thank you for your attention.
Thank you very much, Professor Marina. I leave now to Dr. Cheng Bian to moderate the session for question and answers. Huh?
Yes, thank you. Professor Timoteo, thank you very much for your further presentation. I'm sure we all have learned a lot from your insightful and also very timely lecture on this topic. So now we are open for questions from the audience. For the audience, if you have any questions, please put your questions in the chat box. But I see we don't have a lot of audience at the moment, so if you want to raise your hand, I think that's also okay. In the meantime, I don't see any raised hands or questions in the chat box, so maybe I can use the opportunity to raise a first question for myself to Professor Timoteo. So you mentioned somewhere in your presentation about the now in Shanghai already there's the possibility to trade already data. So I was wondering, of course, the data to be traded, you mentioned it has to be non-personal and also anonymized data. So I was wondering, so in order for something to be traded as goods, it has to be the property rights of data has to be recognized first. So I was wondering how does that formulate at the moment, not only in China but maybe also in Europe or other jurisdictions? Are there already property rights laws, regulations, or policies established for non-personal or anonymous data or information, or is that still in the formulation? Could you perhaps shed some light on that, please? Thank you.
Thank you to your question. First of all, we have to remember that data and personal information are two different things. And the Chinese legislator clearly outlined this as I told you in the civil code, we find the personal information and data regulated introduced in two different sections, and data in general have been introduced with the virtual property. So a stronger stress on the property side of the discourse was made talking about data. But virtual property, we know that this is the property rules related to data are a very new field of the law. Property rules that we find even in the most recent civil code, I mean the Chinese civil code, are traditional property law rules. Our rules, the rules that we find especially in the civil codes, so in the part of the world which we call civil law, in the civil law system, the rules on property law are still mostly linked to the material dimension of property, of goods and of property. It's true, we have intellectual property, we have non-material goods, but we still do not have a general theory of property rules of non-material goods. So we have been assisting in the last few decades to a dematerialization of the goods and of property concepts, and this called to create new rules, but we do not have a systematic set of rules, such as the systematic set of rules on traditional goods and property. And this is particularly true in the civil law context, where in the civil codes, in the beginning of modern era, a specific concept of property was accepted, linked to material goods. In the common law tradition, they have another story. And for them, it's easier to conceive property law rules not strictly linked to material goods. In any case, this is not, it is too complex to deal with this. What I can say is that I am following the Chinese development, because this Shanghai Data Exchange is something new, not only for China. And it's true that this first institution, this first regulation deal with data as goods that can be traded. So we have a connection with the commercial, the contract law rules, but also with property laws. We do not still see a system of rules dealing with property law issues with regard to data, but something is moving, and maybe China will be a forerunner in this regard. So we need to follow the developments, because at the moment we still do not have a systematic set of rules about data from the property law perspective. But it's arriving, I think.
Yes, thank you. Thank you for the question, answer, yes. Okay, I see a hand in the audience. Yachao, please raise your questions. And please keep it short, if you could. Yeah.
Thank you, Professor Marina, and your enlightening lecture gave me a very good experiences, and I would like to comment. Honestly, I have no question. Then my topic is about the enforcement of investment arbitration award. As you said that data could be traded, it could be seen as goods, so then it can be transferred into cash, and then it could be enforced. And if data belongs to a country and is stored in a third country, then it would be raised a question that whether this data could be enforced, or whether this data could be protected by the sovereign immunity. I think is a new idea based on your lecture, and I would like to say thank you a lot. I would to examine whether my idea is worthy in the following research. Yes. Okay.
Thank you. Your suggestion is also very interesting. Thank you.
Yes. Okay. Thank you, Yashao. Do I see another hand in the audience? Is there any more? Yes, Linfeng. Yes, please.
Hello, Professor Timoteo. Thanks for your lecture. I have mainly two questions. The first one is you mentioned about Brussels effect, and we can see that the GDPR has more foreign effects on other countries. But I was wondering how the EU will balance the data regulation and business development, but because we can see that in the EU, we didn't emerge large tech companies like Facebook or Google or Alibaba in China or in the US. That's the first question. And the second question is how does the EU treat the circumvention of the adequate standard? Like the data come from China may meet the adequacy standard of the EU, but we can transfer firstly to Japan, which meets the adequacy standard, but then transfer from Japan to the EU. So that's my two questions. Thank you.
Okay, these are very technical questions, and I'm not such an expert of European law, European Union law, but in any case, I will try to answer telling first of all that at this moment, European Union is still stressing her regulatory power, not only intervening on the foreign companies which do not comply with European rules. We have seen the Court of Justice decision. We had another Court of Justice decisions against Facebook just a few weeks ago. So European Union is going on in her way of enhancing a regulatory standards for data protection, and in particular personal data protection, because we have also always to distinguish personal data protection and personal data and data in general. So we have two different set of rules. If we talk about data in general, we have less stringent measures. And in this case, there is not big contradiction between need to protect data and business interests. But if we talk about personal information, that in that case, Europe still follows a quite strict approach. And this became a distinctive feature of the European Union policy. So European Union wants to distinguish herself just for this capacity of regulatory power which can be followed by other countries. The Brussels effect is linked to this idea. Don't forget that Europe has a technological gap. And this idea to work on the regulatory side was also part of a strategy of filling the gap between Europe and other powers which have a strong tech power, such as US and China. So Europe is still very, very attentive to rules, also to business, but if we deal with personal information, the rules are very relevant. About the circumvention, I have to confess that I don't have the answer. I don't know, because this is I will try to explore this question. It remains a question. If you have some suggestion, I will take it into consideration, but at the moment, I don't have a precise answer to this question. What do you think about this? Technology can always help us in working with roots.
Yes, so I don't think it's very feasible for the EU to regulate to categorize all the data outside the EU, outside the EU. So that's also I'm also considering this question.
Thank you.
Yes. Okay. Any other questions and comments from the audience? I don't see any. So is it, Professor Lee, is it okay if I conclude?
I think, thank you, Biancheng. I think, thank you, Marina, so much for your very rich lecture. We have learned a lot from you. Of course, this, as you said, is such a new contemporary issue, legal issue, and I think that there are a lot of space for us to do research and also to link our research with the practice. And this is, I think your lecture is just a start point for our probably in the future we could cooperate in this area. I think China and EU absolutely are the two active player in the area. I think you have give us a lot of knowledge today, but also bring a lot of questions to us. So it's a very stimulating. Absolutely, we will have some follow-up. But I'm afraid that because of the time limit, we are already access the planned schedule. So we have to stop here. And I'm looking forward to have other opportunity to learn from you and to share our research in this area.
I hope so. Thank you, Professor Li Yuan, for this invitation. It has been a great pleasure for me. The important thing is not to have answer, but to raise questions. So this was a good occasion to raise questions, also to me, because to prepare the lesson, I started with a lot of questions. Many of them are still unanswered.
Yeah, great. Thank you, Professor Marina. And also thanks to all the participants. Most of them are PhDs from Erasmus University Rotterdam. And I hope you enjoyed the lecture, and good luck with your research, and enjoy the sunny day here, but very windy. I don't know how is the weather, Marina, in Italy?
In the weather is okay, sunny day, not windy.
Okay, you are lucky. All right, thanks to everybody. And
okay, I hope to soon.
Yes, thank you. Bye bye.
Bye
Thank you.
bye.
Yes. Bye bye. Bye bye.
Bye bye.
再见。